A lot of people ask me, how long does a will contest take? And the truth of the matter is, it's pretty difficult to assess or to forecast how long each particular will contest is going to take. However, there are a few factors that we can look at to make that estimate easier. For example, we can look at the grounds for the will contest. We can look at the ease of getting evidence, and we can look at the willingness of the parties to settle. So let's look into the grounds first. You have grounds such as incorrect execution of the will, or lack of mental capacity to make a will, or undue influence in making the will. If the ground you're basing your strategy on is the execution problems, that's probably going to get resolved pretty quickly, because those grounds tend to come up in the beginning of the lawsuit when witnesses of the will are examined and when the lawyers who made the will are examined. If you're basing your will challenge on the lack of mental capacity, that might take a little longer because it takes time to get evidence from doctors and hospitals and from other people involved in assessing capacity. If you're looking at the undue influence ground, if that's your main strategy, that's going to take even longer than the first two, because you'll need to then examine other family members and people who know the situation, people who know the person who had the will, and really look into the situation, what happened. You'll need more time for that, depending on the ground. The second factor that makes a difference in how long a will contest takes is the ease of getting evidence. Sometimes it's easy to get evidence, sometimes it's not so easy. Some people take convincing before they'll provide evidence to us. For example, medical records from hospitals. Sometimes we have to call them a few times before they get the medical records. Sometimes they refuse to provide it, and we have to go through the court and force them to provide the records to us. Same thing with witnesses. Some witnesses are easy to find, easy to reach. Some witnesses take some convincing, and some of them have to be forced through the court to come in and tell us about what happened in the case. The third factor that I think is important in determining the length of a will challenge is the willingness of the parties to settle. If the parties' relationship has deteriorated to the point where they cannot settle on things to a large extent, then it will naturally take them more time to settle things. The last factor that I want to talk about that makes a big difference in challenging a will is the strength of the case. Cases that are perceived as obviously weak cases or obviously strong cases tend to be settled faster than the cases that are in the middle, borderline cases, where it would take some time to determine whether or not the case is strong, and where there's a disagreement on the strength and weaknesses of the case. Those are the cases that take more time to get settled. Whether you're prosecuting in a state case or defending in a state case, an experienced state attorney will have the leverage you need to expedite the case and get a more favorable pretrial settlement or a higher chance of success at trial. So if you have a will challenge and you're looking for an attorney and you need an experienced one who knows this practice, give me a call, we'll talk about it. I'll be happy to give you a free case evaluation.